First take. Nailed it.
Yeah. All right. Call to order the Rice Creek Board of Managers regular meeting. It's Wednesday, September 11th, 2024. It's 9 a.m. Let the record reflect that all managers are present. Mr. Administrator, any changes to the agenda?
Staff have no proposed changes for the board to consider.
Awesome. Any motion, please, to set the agenda?
So moved.
Second?
All in favor, say aye.
Aye.
Opposed? None. Okay, we're at minutes.
Yes, Mr. Chair, I would make a motion to approve the minutes from the August 28, 2024 regular meeting.
I'll second that.
Any discussion? All in favor, say aye.
Aye.
Opposed? None. Brings us to the consent agenda.
Yes, President Bradley, Board Managers, staff have 4 applications on the agenda today. Happy to answer any questions.
I have a couple. Permit 24-043. The table shows 80% being less than actual. Is that okay because it's within the normal range? I mean, normally you throw a sentence in there that makes me happy.
Yes, within the tolerance of the model.
There you go.
If you'd like us to, I guess it is say that in there, with rate control requirements of Rule C7 within tolerance of the model.
Okay. 24048. I would be absolutely amiss if Barbara Hockey's presence in this room isn't being felt at this moment. We have a truck washing facility, and there's no discussion about where the runoff from the washing of those dirty, oily trucks goes.
I don't know. Good question. I know we've approved other car wash facilities in the past as well. I don't know if that's anything that's specifically captured in our rule. Chris, I don't know if you've got anything that you can mention on that.
Sure. Members of the board, the car wash is similar to this. They typically handle the water that comes off the car washes as essentially sewage. Typically, or on a lot of these car washes, and I can't confirm on this one, but a lot of them, they have scrubbers that they use so they can actually reuse the water within the car wash system. They have a reclaim type system within there. I don't know the details of this particular one, but certainly within the car wash, it's not going to have a resultant stormwater runoff that is coming off of the cars. It's contained within the facility and handled via the sewers, what have you.
So where does the sewer water go from there?
I'm not sure if there is a municipal sewer system out here on Hornsby. If there is, it would be going there. Otherwise, it would be going to an on-site septic.
Mr. President, there's municipal stormwater on Hornsby. I can tell you from our business, we had a settling tank that all our water went into, and everything settled out, and then they actually monitored us at the street.
Well, there's normally someone cares, but I'm thinking we're one of the people who should care.
This was Anoka County that was monitoring ours. I mean, they monitored it periodically without telling us at the street level so that they were seeing what we were putting down the sewer. And you had to meet
I'm inclined to have
requirements.
us pull this until we find out. I'm just,
Manager Bradley, Board of Managers, certainly the board could do that if it finds it appropriate. As Patrick noted, our rules do not look at sewer, rather storm sewer.
we are responsible for reporting to PCA, for example, if there were contamination coming to our ditches.
Yep.
So we are still responsible for what comes off that premises besides just the amount of water.
Hornsby's on the east side of 35.
Yep.
E, and that would go right into ditch number 4.
So the other alternative would be to add a condition
Manager Bradley, I like that idea. We've done that in the past where we look for staff to close the loop so that we ensure that the entity that has the authority over the the sewage or the sewer or the on-site disposal of it is aware of the situation and confirmation that it's within their jurisdiction, they're taking matters accordingly.
Something to the effect that, as a condition, that they demonstrate that the runoff from their operations of the truck wash do not flow untreated into our ditch, into the stormwater, something like that.
Contrary to whatever
Standards there are, yes.
present. Yep.
Yes,
Mr. Chair, in that condition, we may just want to refer it to we have a rule, our illicit discharge rule, which in managing our ditch system, we have a standard that non-stormwater may not be discharged into the system. So
fabulous.
the condition can reference that.
Great, thank you. Thank you for your help. So with that, I would, are there any other questions or discussion?
Mr. Chair, just a quick comment before we do that. I don't know if actually tabling it might be the right idea, just so you can communicate with the business owner, because there's nothing more frustrating than applying for a permit, receiving this information that's in our packet to review, and then to ask, and I'm not saying complying with already existing rules is a bad thing, but I just think communication is appropriate before we are to do that, to ensure that, number one, we're the agency that should be. I don't want to outkick our coverage, right? Like, I understand we have responsibilities. In my own personal experience as it relates to car washes, to Chris's point, the water is recycled and reused within the site. It doesn't go into,
Until it's not recyclable anymore.
well, understandable, but again, I think that warrants a conversation with the applicant. That's just my opinion. Obviously, we are everyone's entitled to vote how they want to, but I think a conversation with the applicant would be warranted prior to
Manager Robertson,
approving.
I believe that's what we decided to do. We're going to add a condition requirement that they demonstrate that, in fact, they are not putting their effluent back into the.
Again, and I understand that. I just think having that conversation before you amend this by including additional conditions or variances or what have you, I think just a conversation wouldn't be a bad thing. That's all I'm saying.
And, Mr. President, is there not other agencies too that would be looking at this? I don't either. I mean, I would assume the PCA or somebody should be.
I don't know.
Looking
That's
at
why
that.
all you do is say on, one of the
Yeah,
conditions is that
right.
they must, in fact, do something to protect their.
Mr. President, instead of a condition, you could just plain pull this for the moment until a conversation is done and bring it back to the board in 2 weeks.
My way doesn't delay the 2 weeks.
You would? I'm sorry.
My process would not delay anything.
Exactly.
I'm not sure where they're at the city, but in their process.
President Bradley, Board of Managers, just further on the condition proposal, certainly if that is what happens here, it's approved, we would have the conversation with the applicant and their team about it. And if for whatever reason this wasn't considered, there's an issue that causes them to do some sort of redesign or whatever that might be, we could not issue the permit, have them amended, come back to the board with an amended conditional approval proposal. Depending on how that conversation goes, if it is straightforward, they've got it, they can demonstrate it, then the condition would be satisfied.
Could we pass it contingent on finding that information and
That's what
then?
Caprock is.
Yeah, so that they don't have, they're not losing
Time.
time. Yeah, that's my concern is, for them, time is money, and I don't know where
Robertson's
they're
right.
at.
We should do this in a way that doesn't unnecessarily put a 2-week delay in this process.
If we could pass it with just the condition that we have to hear back or something, that to me would be a better solution, but
That's fine.
So, Mr. Chair, procedurally, I think we can approved 3 permits on the consent agenda. And I believe you've requested to pull 24-048. We've just had discussion about that, and I suggest we pass that separately from the consent agenda. So I would move that we approve conditionally, to approve conditionally approve pending receipt of changes or deny the, okay, hold on. That we approve permit application number 24-042, 24-043, and 24-052.
Second. All in favor, say aye.
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 Opposed? None. So then I would propose that we amend 24042 to add an additional cap rock that the applicant provide information concerning how the treatment of the water that comes off the truck washing process.
Mr. Chair, that's actually 048, not 042.
Excuse me, thank you, 24-048. Yes,
Mr. Chair, a suggestion to word that as a condition that the administrator will confirm that the design meets the district's illicit discharge rule?
Yeah, thank you. I was just gonna bring that up.
fabulous. I accept that
Yeah.
change.
Good.
There you go.
Is there a second to that?
Second?
All in favor, say aye.
Aye.
Any
No.
opposed? One no. Okay.
Manager Bradley.
Yes.
Board of Managers, next on the agenda would be your public hearing on your proposed rule revision. You've been given a script that introduces the activity or the agenda item to the public.
Okay.
It's on page 41 of your packets.
So, good morning. This opens the public hearing to receive comments on the proposed amendments to the rules of the Rice Creek Watershed District. Previously, on July 24th, the Board of Managers authorized the distribution of those proposed rules. We're presently at the 45-day comment period, seeking comment on the proposed amendments. Hearing today is to allow interested members of the public to present comments to the board directly. This public hearing is required by state law and part of that process. So during the public comments, managers are welcome to ask questions of commenters to clarify their remarks. I also may ask Mr. Hughes or our engineer to respond to any technical questions raised. I ask, however, that if the manager then wishes to speak to the merits of a proposed change, this be reserved for a later time when the board will have the opportunity to discuss the changes. At this point, I open it up. Patrick, would you care to proceed?
Yes, thank you, President Bradley. I have a presentation here. Okay, presentation, this will be pretty similar to what the board saw, I believe, at the June workshop. A few minor updates here and there, but you know, and it's essentially an overview of what changes have been proposed in the rule, just so you can see what those are like and the folks that are here attending the public hearing. Oops, that's the wrong one. So outline just an overview of the priority revisions. We don't have any large-scale policy changes that we're proposing during this rule revision, more towards clarity and flexibility to applicants. We'll go over the priority ones, and then I'll have the next steps and timeline as we move forward. Of course, the public hearing and folks provide comment, and then address any board comments and questions that there are. So kind of breaking it out for rules, each individual rule, we'll go through the stormwater first. This first one relates to definitions. In our stormwater rule, we use the term connected action. And we're looking to update that to match the MS4 language of Common Plan of Development. This really doesn't have a really an effect on our administration, but provides that alignment and clarity with, how it's done across MS4 permit holders. Regional stormwater basins. This is something that comes up somewhat frequently, and there needs to be some additional clarity in the rule for what we're requiring to say that projects that are proposed can utilize existing regional basins. So the solution here is identifying the need for an established maintenance obligation to have permission from whoever might be owning that facility. And then we would be proposing to delete proof of maintenance. This is something that then we'd be able to enforce or administer through the maintenance obligation. And we would see this adding greater flexibility than our current rules. Landlocked basins. Currently, the rule requires that to provide an outlet to a landlocked basin, you'd have to demonstrate that the back-to-back 100-year, which really doesn't provide a solution necessarily if you have a landlocked basin. So the solution here, what we're proposing is to provide an outlet can be provided if it is above the 100-year critical event. And the other conditions within that rule still apply if we're looking at wetlands, if we're looking at downstream impact, things like that. Our total phosphorus removal table for stormwater BMPs. What we're looking at here, we reference stormwater ponds and also NERP ponds, so that's not clear, and it's a question we get frequently. And there's also a reference specifically in the table to stormwater wetlands, and that's really not something we see proposed. So our solution here would be to clarify that ponds would need to meet NERP standards, and removing stormwater wetlands from the table. That doesn't preclude someone from proposing that in the future, but it just helps keep the table a little bit clearer. BMP location siting. So again, this is something we're looking at to clearly meet the MS4 permit requirements for on-site treatment and volume control. We looked at both the references for public linear projects, but also non-public linear development. So we removed the reference to the resource of concern for public linear projects, and then provide some clarity in the requirement for infiltration first and foremost, on-site requirements, and then the sequencing that you can go through if you're looking to provide stormwater treatment off-site. Design criteria, this one specifically to infiltration, biofiltration, and filtration basins. If an applicant's looking to utilize those for rate control, there's nothing in the rule specifically that mentions the need for an outlet control structure. So simple addition here, that an outlet control structure to convey the 2, 10, and 100-year events. And then we also added a definition for outlet control structure in Rule A. Underground BMPs, somewhat of a popular approach now when folks are constrained on their site size. A challenge with these is, they're underground. So it's difficult to visually inspect those. It's something that we ask about, but we don't have anything specifically in our rule related to it. So we would look for applicants to design these systems to provide inspection and access ports. Allows for easier inspection, easier maintenance, things like that. Uninhabitable structures. This is something that has been one of the more common variances in the last couple of years, specifically for structures that are not meant for human habitation. They may not meet our freeboard requirements, whether that's a foot or 2 feet or what have you. So the solution here, we've talked about this at other board meetings too, but a structure not meant for human habitation would be exempt from the requirement if the district finds it is impractical, and the landowner files a notation on the property that the structure does not meet the freeboard requirement. In the variances that the board has approved, this has been a typical conditional approval item that they've made for that. So this would provide the flexibility to the applicants. They don't have to submit the variance and go through the whole board process, but we're still getting the same protection. Public drainage system easement. This has been a challenge and maybe an unnecessary burden for our public partners in providing the easement over the public drainage system through the permit process. Currently, our rule does exempt public linear projects, but we would look for this to also include public property from providing that easement. We have the implied right-of-way through 103E, and our public partners at this point, I think, are quite well aware of the existence of the system and its necessity. So we're proposing this change. This would be in 3 of the rules specifically: stormwater, floodplain, and in the public drainage rule itself. And then easement requirements on partial developments. This is stemming from a recent Lino Lakes application earlier this year. They acquired property as part of a lot split to provide a water treatment facility, and then other portions of the property retained by the private owner. And that, the way that the rule is written, the private owner would also have to be providing easements and declaration for public drainage system or wetland management corridor, things like that. So this specifically would be for those sorts of instances. We would not require those easements for a retained part of a privately owned tract that is subdivided to convey land to a public agency for a public purpose. I don't know that'll happen too frequently, but again, provides flexibility. Non-residential phase development. This is C13 in the stormwater rule. I don't know, it's a couple pages. It's pretty complicated. It has different terms in there, and it's not something that we've really seen folks utilizing for a few years. And we don't expect that, there's any that we have existing C13 approvals, and we don't expect that, just based on land use, that this is something that we would see in future projects, this large-scale planning for non-residential development. So the proposal would be to remove this C13 rule, but still noting that applicants can still have an extended permit term if they request it, and we can do that through Rule B. Rule D for erosion control, stormwater BMP maintenance, a hot topic item here, but we don't want to create obstacles for folks that want to maintain their BMPs, making them, go through a permit process for it. So this would be to say that a permit is not required under Rule D to maintain an existing stormwater management basin, but we would look for a notice of intent so we can kind of demonstrate that, they've done that work. We can put that in our record. And other rules could still be triggered based on the circumstance, but specifically for Rule D. Rule E, floodway. This is something that's associated with the National Flood Insurance Program. It's not something that the district regulates or manages. So we would be looking to remove the reference to floodway. And this is a policy that we've had in place since 2022. And then this would just be the rule kind of catching up with that. And the floodplain fill exemption, currently it's a one-time opportunity of up to 100 cubic yards. We're seeing this as an equity issue for only that single opportunity. So we would be looking to remove that one-time deposition, still allowing the 100 cubic yards in total, but then folks could have it over multiple projects, multiple permits, whatever that might be, and we'll still track that amount, but making it so it doesn't have to be only one shot at it. Wetland alteration. This relates to the rulemaking effort that Bowser is working on as far as wetland replacement siting criteria. Yeah, so currently, so the Bowser proposal is that yeah, it would have to be, I'm sorry, this would be a requirement that, yeah, I have to step away for a moment.
Yeah.
Sorry, I think I locked my legs or something.
Okay. brief break for health
Certainly.
reasons.
It's like a 5-minute break.
Thank you.
Oh, it's so funny, I'm reading.
Want to check on?
If that's a rule about illicit discharge, wouldn't that have been checked in the application?
Yeah, we do have an illicit discharge.
So the worst thing that can
See what you think of that.
son of a cardiologist is people have something happen to them. when they get
I
embarrassed
was that
and go
kind
in
of
the bathroom and
confuses me
die.
from the start.
When I reviewed the ER, I didn't specifically focus on, I assume.
So
I'm glad
in other
this-
words, on the
I'm glad you
checklist,
went
it
to
wasn't
check on it.
checked off, is what I'm saying. You know, I mean, when a rule comes in, you guys have these rules, they're all a checklist, you must go through them, check, 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 check. That one wasn't explicitly looked at, is what you're saying. So the staff has to take a look.
Illicit discharge in connection, so
I mean, it would be Houston.
it's just a simple reference to that in that permit.
It's not, Chris doesn't do permits.
Good
You're
catch.
saying that was
Barbara Hockey was yelling at me.
So it's a matter of just verifying.
You know, you
I
said
said
something.
that.
And I had
This is
already
how it
found
got
this,
you know, checked on the list, and nobody knows here, they're gonna say that, so. All right,
Yes.
answer that question.
Barbara Hockey would be
And
all
also,
over.
there's the state, there's a state MPCA permit that also prohibits discharge.
Somebody,
Yeah,
Wash
yeah,
water.
yeah.
And so I'm sure it was designed.
sense to me.
I suppose I could follow
Okay,
up.
then it is
Oh,
what
it's so good to see you the other day.
By the way,
I guess in the future,
It
that's
was
one of
used
the
in vain.
checklists that ought to be in there.
not in vain.
Actually, it was,
Some
oh
time
yeah, I'm
ago,
Barbara. And then we're sitting on the Mississippi, and she goes, I don't like that. I got this river
There's
dredge.
a car wash up on Hornsby
I
already.
bet you did.
Yeah,
took me
that,
20 years, but
Love Station's
was
got
the
a
first
truck
to be
washing
recognized.
facility up
She
there already.
was. She
Yeah.
was.
It had to be.
when was that built?
That's been up there a couple of years now.
She would go down and spend half the year down in
It's
Florida.
slow, but it's got a huge
Disappear.
truck facility up
You
there.
know,
right
calling
on
on,
Hornsby.
couldn't vote, couldn't,
So they've got to use the same stormwater system that goes down to Hornsby Street, and I know.
Or they have a self-contained system. if
Well,
it's-
whatever.
What was he
they
having?
have that rule would have had
you
been
last night?
in existence. And
Hope he's all right.
I was cheering.
yeah, it's just very. I don't see how it holds up.
We did a
Permitted,
wonderful,
really. It's just
had a wonderful turnaround.
staff would just have to take a look.
I think it's not just what a disaster would have been.
Yeah.
Is he okay?
Managers, Patrick will be back in a moment. He's just, something came over. Whoops, excuse me. Who knows what?
More than happy to.
Yeah.
Yep.
He intends to retake the podium here in a moment, just something flushed over him. He's getting a drink of water and we'll start momentarily.
As a son of
No
a
problem.
cardiologist, I've been told many times, when you don't feel good, don't go into the bathroom and disappear.
Yeah. Good point. Got to look out for each other.
Exactly, exactly.
We'll continue with the
That's fine.
public hearing and wetland
Do you
replacement.
want to move on to it?
I expect many, I think he's just, yep. I think we should be
Here he
good.
comes.
It's a lot of information.
Welcome back, Patrick. I hope you're feeling okay.
Yeah, doing fine. Had to make it exciting, right?
Well,
Little change.
not that way.
It's pretty dry otherwise. Jumping right back in. So replacement siting. So this relates to the Bowser rulemaking effort. They're looking at revising it from minor watershed, major watershed. They're going out to the bank service area. So this would be a couple of counties even outside of Rice Creek where you could be providing your wetland replacement. So our proposal would be to capture that resource within Rice Creek. So replacement by banking would need to use credits from banks within the district. Of course, unless those are unavailable, they've all been used up, whatever that might be. So the resource benefit remains in Rice Creek then, and then we would have the CWPMP language would stay the same, and that might be more restrictive.
Do we need to have a outside limit on how far they can go? I mean, replacement by banking must use credits from banks within the district unless unavailable, in which case the credits must be within.
I would be fine with it
Say-
then matching the WACA rule change to the BSA 7. That would be pretty consistent with what it would be currently.
So you would need to add language to do that, wouldn't you?
No. Manager Bradley, if I'll paraphrase what I'm hearing Patrick say, is that the existing Wetland Conservation Act rules include bank service areas, and there's a hierarchy within that.
Okay, so that
So-
just automatically applies by law anyway.
Yep, once you're outside, then you'd step through that process.
Super, thank you.
Rule I, public drainage systems. It's a challenge for private landowners to provide the easement for the public drainage system on some projects that are, solely trigger Rule I. That could be like a crossing of the system, a bridge, whatever it might be. But challenging for just, what could be a single-family landowner to do this outside of like land development. So the proposal here would be to remove the public drainage system easement requirement for projects that solely trigger Rule I. We would still have, of course, the 103E protections, the implied right-of-way and such, and we would still require the easement under other rules, but more towards land development. So if you triggered Rule I and Rule C, you would still need to provide it. Temporary crossings and obstructions. There's nothing explicitly in our rule related to temporary crossings and obstructions of a drainage system during construction. So we would look for applicants to provide this information on the front end to get their permit, specify, what they're doing, and how they're, enabling unobstructed conveyance of a rainfall or flow condition within the ditch system. So if they're, pumping it or, going around, we'd look for that information on the front end. Rule K, enforcement. Currently, the rule is rather general on our authority to take action on non-compliant issues related to our permits. Our council has provided some additional language to add in there, which, just kind of goes through not limited to permit suspension or termination, the right to enter, to inspect for and correct violations, the right to be reimbursed for costs incurred to do so, civil action or joint powers municipal assessment. I'm still working on a separate policy. The board would, I would look for the board to adopt that via resolution like they have previously. I think the last one was in 2019, but it would kind of go hand in hand with this. Not yet ready to bring that to the board, but hoping to do so here in October, looking to kind of have both the updated compliance go hand in hand with the rule, so kind of looking for that January 1st, 2025, if possible. And variances, this is just a simple change in here. Undue hardship and practical difficulty are the two presented options for folks to request that variance. Undue hardship is a more outdated term, and it's not one that we have utilized with many of our recent variances in the last few years. So we just look to clarify that it is for only practical difficulty. Yeah, but it has really, no change in our administration. It's a term that stems from, I believe, a city process. So it's a term we just kind of adopted anyways.
Patrick, could we go back to the enforcement rule?
Of course.
Okay. So the district may use all other authorities it possesses under statute. I would prefer it said possesses under law, because it's often difficult to find specific words to quote directly into the statute, but the implication of the statute under law would support the actions. Chuck, what your thoughts on substituting the word law for statute there?
Mr. Chair, I think that would be fine.
So that's one of the two changes I will be proposing at the end of this. Thank you.
Perfect. Yep, took a note on that. And then, yeah, that's, I guess, all of the priority revisions. So if we're looking at the timeline, of course, we're here at the public hearing today for comment. The comment period will go until the end of next week. It would be September 20th. Once that's closed, we'll consider any comments that we've received and work on, the final rule language. We'd bring the proposed rule to the board at the November workshop. Assuming everything goes forward, then we'd look for the board to authorize, I guess board approve through resolution, the adopted rule at the November meeting, and then that would be for a January 1st, 2025 effective date. I guess I could just mention at this time too, we've had one written comment come in, pretty minor clarification change in a table, but that's what we have so far, and we'll see if there's verbal comments here today or if we get written comments by the end of next week. Yeah, and I guess that's all I had in my presentation.
John?
Mr. President, thank you. So the Board of Managers received comments earlier when this was first put out from 4 cities, Forest Lake, Lino Lakes, Hugo, and White Bear Lake.
Correct.
And then those were presented to the board. Are those comments in the record?
Yes, we will. They've been put into the record for now, and when we have our formal response to all comments received, we'll include those in the table, yes.
All right, so they're not lost in this one.
No.
The way you sounded like there's only one comment, but, there are pages of written records.
Yes, I'm sorry, Manager Wall, I should have clarified. Yes, we received comments during an early initial
All right.
period. During this formal comment period, we have received one
Okay.
written comment.
And then, so they're included, the prior comments are included in the formal comment period. Could you just give me an idea how many of those comments were incorporated into the changes?
I'd say a couple, 3, 4, maybe.
Okay.
So Patrick, in addition to my suggestion of changing the word statute to law in that one site, and Rule K, I believe it was, on page 25 of the Rule 78 of our packet, what page? 78
Thank you.
of the packet. E says underground stormwater systems must, I think you need to add the word be, that's monumental, must be designed to provide. Typo.
Oh, yeah.
Sorry, I don't quite see where it is,
Okay,
Manager Bradley, I'm sorry.
On page 25 of your rules, if that helps. The new E.
Oh, yes, I see it. Okay. And I'd also point out, Manager Bradley, you previously made, I think it was the last board meeting, you made a comment about the 100 cubic yard exemption and the variance request that we had come through. So yes, we also are looking at that. We'll provide that response to the board and what we've assessed on it, and if we can make a further change there.
Appreciate that, thank you. Yes.
So I have some general comments, unless you're taking
ahead,
it from
no.
the public at this point?
Let's go ahead, unless if they aren't specific about word language changes from here,
Right.
unless you have a question.
Nope.
All right, is there anyone in the audience, so I see we have some of our regulars here, who want to discuss our rules? Is there anyone on the phone?
Sure, I'll take a shot at it. Christopher Stowe, 426 Pine Street. I wasn't actually coming here for that, but the presentation presented itself, so here we are. When you talk about structures in the wetland plain or something like that on there, I run an equine boarding facility that's been established since 1968 under a special use permit through the village of Lino Lakes. So if you say that, in that, I can erect any temporary structures I need to for farm animals. So if I need a horse shelter over here, now I need one over there, I can throw them up wherever I want. And I don't need a building permit for that. Changing stuff like temporary structures like that would impose something on me that I'm already allowed to do, I think. and your structure's one. As far as your access to the drainage system, I'm confused by that too. The city of Lino Lakes just passed an ordinance change to basically have easements on all the drainage systems. So the branch of 102232 that flows through my backyard, is that your guys' easement or is that the city of Lino Lakes? When you do easements too, typically if they want to put in a sidewalk or something like that, they say, hey, we're gonna cut down your trees and clear the land and put a 6-foot ADA accessible trail 10 miles like they've been doing in Lino Lakes. The landowners get paid for their easements. I still don't know if I even own my own ponds. So there's some significant stuff in there that's incorrect too. I like your suggestion of changing it from your statutes to law, but then you guys are assuming that you're the law enforcement agency for the wetlands, and you're actually not. That would be the DNR, I believe. And I think 1022, is Rice Creek actively paying fines to the DNR, monthly, yearly, quarterly, for violations? I'd like to see that information. But as far as the law changes, to just generally change that and send that out to the public and nobody looks at it other than the other cities, and they're all kind of double dipping on the who's got the authority. From a landowner's perspective, I should be able to talk to one person instead of jump through a bunch of hoops. And when I initially had my problem with the city of Lino Lakes, they weaponized you guys and the DNR, and everybody came at me at once, unlike what the administrator said, because the DNR guys issued me a ticket the same day Terrence Williams or whatever, Terrence Davis, something showed up. So anyway, I don't like any new laws and changes because it seems like the farther we go down this path of we have a wetlands district and this was our rules, but now stuff's changed and now this. You get far enough down that road, you don't remember what the original goal was. And the original goal was to actually protect the wetlands. But now we just sell wetlands credits and build huge complexes on Lexington north of Fleet Farm and haul in all the dirt from the stadium and buy your wetlands credits and let's go. But in the meantime, I'm still underwater and I don't know what to do about it. I've asked everybody to help me. Oh, I was misquoted too in the note. I know you guys accepted the meeting minutes of last meeting. I couldn't make the 10/22/32 workshop, but when I said they lowered the ditch, that was the city of Columbus on the north side of Pine Street. I was told that they were responsible for the ditch, but the ditch is part of 1022. So the pipe you guys lowered, the ditch they lowered. I don't know who cut the street. Lino wasn't officially notified, and nothing's been increased in size or lowered downstream. So I don't like any changes in your regulations because the more we water stuff down and change how many, well, you got the King James Version of the Bible, you want to keep changing it. How many times do you want to change it before it means something completely different? Thank you.
Anyone else care to speak?
Catherine Decker, 614 Pine Street. In the last, towards the end, you were talking about the enforcement change and you wanted to change it from statute to law. I think you guys do yourself a disservice when you do that. The statute, to me, seems pretty specific. There's the statutes that you can pretty easily look up and they are helpful in discussions of law. But I think that if you go to law instead of statute, you've now expanded the umbrella, which I think was your intent. It sounded to me like you wanted to have more opportunities for decision-making, presumably in your the board's favor. But that seems to do a significant disservice to the public. I think the public would be well served, and so would the board, everybody involved, to have clarity on what is accepted and what is not accepted. And it seems to me that the statutes provide more clarity than the law.
So the law includes the statute and rules that have been adopted in explaining the statute and court decisions applying those statutes and the rules. And all I'm trying to recognize is if you just limit it to the statute, you've only got one of the three pieces of the pie. Didn't understand what the law is. our obligation is to enforce the law. Which includes the statutes.
I just don't want you, my advice to you all is to, make decisions that clarify the water as opposed to muddy the water.
And I believe that that is actually the intent of these changes. Thank you for your comments.
Manager Bradley, Board of Managers, you might want to ask once more if there's anyone else that would like to comment. Otherwise, I can see staff diligently taking notes, and of course, all the comments will be laid out and propose some consideration and potential responses for the board to consider.
For the purpose of the record, I will ask once again if there is anyone in the public who would like to comment on these proposed rule changes. I don't believe there's anyone on the phone. Marcy, you said you had some comments.
Yes, you will note that the last time we did this was in 2020, and we did it all online because we were in the throes of COVID. I was a new manager at that time, so trying to understand all the rules and how they applied and how it intersected with the CAPROC and our applications that we had before us. So I would just point out, and this is probably clarity for me, is when we are looking at the applications for permits, let me go back to that. Patrick, you lay out the conditions by which that permit would be approved. And Mr. Attorney, you had suggested in the permit that we had been discussing about the car wash, to include illicit discharge, which are Rule H. So going back to that discussion, I just want to be clear. Basically, you are just adding, Patrick, considerations in the permit to point out Rule H, because I'm looking at, let me see where we're at here.
Manager
Okay.
Wine?
Yeah, you can help me out.
What I'm understanding you to say, Manager Wynant, is that staff and engineering firm are making a recommendation. Typically, it's CAPROC, but sometimes we approve permit. The most recent one that the board discussed just today earlier in the additional CAPROC item, I would, as you note, be reference to the rule about illicit discharge and look for the applicant to show compliance with that before staff, based on the board's action, issues the permit. So,
Right. So to be clear, on page 31, you would just note something that says, that just references Rule H.
Yes, I would put it under a new heading that doesn't exist there,
Yes.
a Rule H heading to have that conditional item in there. I don't
Right.
have it up in front of me. I think it would be a new number 5, I think, from what I remember.
There you go.
So, I mean, I'm just clarifying that unlike the other rules that were referenced on page 31, this one would be just simply inserting that and making sure that the applicant was aware of it and that we had some certainty that we knew what was going to happen to the discharge.
Correct, yes. So this document here, this engineer's report, it's our findings of how any given project is meeting the rules. So when it's an applicable rule, we want to have that documentation in there, yes.
Okay, thank you.
Mr. Chair, can I ask a quick question? Patrick, can you put up the slide just with the kind of next steps and the date timelines? Because I just want to, I have a couple of questions, but it looks like we have another workshop scheduled to dialogue this before final approval. So, I mean, I'm not going to get into it here. This is the public's time, but I just wanted to ensure that I understand that correctly, that we still have opportunity to dialogue or ask questions or get clarification on some of the proposed changes.
Manager Bradley, Manager Robertson, as Patrick brings it up, you're correct. This
Okay.
is the public hearing, and
Perfect.
I see Patrick has it.
I just wanted to make sure that was the case. Okay.
Yes, if you'd like to provide a written comment, certainly you can do so as well, and that would be to the September 20th, and that would go specifically in our response to comments. But certainly, yes, the board will have another opportunity. We're
Perfect.
planning for the November workshop.
Okay, perfect. I'll reserve my comments for that time then. Thank you.
Mr. President?
Yes, sir.
I just wanted to comment on one thing that Chris said up at the microphone I do agree with, and that is trying to eliminate any duplicative rules whenever we can. And I don't understand on the easement, I don't know that, but the city has an easement also on the,
Mr. President,
that's new to me.
Mr. President. Yeah. The word easement, I don't think is proper language for the drainage system. It's right of way. And there's a difference, at least in my experience, since I have a piece of the drainage system through my property. And I also have a public road, but I have no easements on my property. So that language of easement is different than right of way. And I don't know the technical difference. You'd have to, gentlemen of the background in the law would know. But I assume that we're not really talking about easements. It's just a misunderstanding. And second of all, my opinion would be that the city really doesn't have authority over the drainage system, as I know. At least, except in where the district has specifically delegated that authority to a city, such as in some places like in Forest Lake or in Roseville, which we've done that in the past. But and I don't see the word easement in the public drainage system rule I here. And so.
Manager Waller, Manager Wagaman, maybe a couple of points. The first one, I think, is commonly referred to the belt and suspenders approach. So the drainage system in its existing condition, right? We have the implied right-of-way through 103E, and we've tied that program to the regulatory program to get a formal easement as property develops and such. So the difference there is if we've gone through the process, it is a specific easement document that is then recorded on the property title. So there's various ways that can be brought up through the permit program. And it's just, another way to provide that protection or whatever it might be through multiple programs. As far as the city process, through development projects and things or the platting process, the city commonly would obtain like a drainage and utility easement or something, and that could fall over a drainage system, would be my expectation. So
Well, I've got some other questions too, but even on that, I'm not sure I totally understand, but I will do the same thing. I'll wait till we have our workshop where we got time to dig into it,
So,
thank you.
Mr. President, this question about easements was something a long time ago when I first came on the board, and we changed those rules. So they used to be like 50 and 100 feet. And I think it was from center line, I'm just going to say. And it seems to me that we narrowed those up quite a bit to just be what the implied right-of-way would be. And so if you're saying when a application comes in for development of a property that has a part of the public drainage system on, and as that part of that application, you're requiring a more formal designation as to what the right-of-way is in the form of an easement, then it's important to understand that you're not expanding the authority of the district geographically.
Correct.
You're just keeping the easement within what was the right-of-way. Is that the way I understood it?
So the rule is written, it's 40 feet perpendicular from, as far as easement, 40 feet perpendicular from the center line of a tile, 20 feet from the top of bank on both sides. That can be refined based on the project itself. But my understanding of it is that, so while we're, getting the easement there, it doesn't affect the right of way if we're doing projects.
Just a
and
more,
things like that.
yeah. And so in my instance, now I know Washington County JD2 is special. Because the judge at the time when he authorized that, he said the right-of-way will be 33 feet from the center line. And I've been told numerous times by numerous people, this is the only one in the state like this, theoretically, they claim. So the point being here is that if the development of a piece of property came in on JD2, which now has a judicial order that says you have 33 feet from the center line of the ditch, says self-monumenting ditch, wherever it is, that you'd increase that to maybe 40 instead of 33. Is that correct? If you were going to have for an easement?
That's a good question. Yeah, we'd probably look for input from our drainage team on what might be necessary there to complete maintenance, repair, whatever it is.
Yeah. Well, I'm just pointing out to you is that the purpose of changing that rule from the 100 to 50 feet was 100 feet on trunk systems and 50 feet on non-trunk system drainages was to narrow up the authority over the property owner, because right of way, the property owner still owns the property. An easement may grant other individuals the use of that property, not just public entities, so.
Manager Bradley, Board of Managers, just one thing to note on that, and Manager Wall, you're correct that the intent here is to provide something that provides clarity to the landowner and what the district's land right is on the property. I'll just note that even with the district's right of entry or with any easements that the district would have out there, it does not provide the public access to it. It's only for the district and its authorized, consultants or team to be able to access for the maintenance and inspection.
It's not a canoe trail, correct, Chris?
Correct.
All right. And Mr. President, I also have some other comments about this generally, a few today and then later on at the workshop. I'm curious, when I first came on this board, we also made another change in the rules, and that was from 2,500 square feet for a permit to 10,000 in the disturbance, And I'm just wondering why, when Forest Lake asks for 1 acre, the 43,000 someone, I've forgotten exactly how many square feet are in an acre. It's 43,000 something. 560 is that?
43,560.
Yeah. And why, just for the sake of the issue of duplication, for example, can you show me, Patrick, where there's some metrics that shows that 10,000 is better than 2,500 and that 43,000 is too much or something like this? To me, that seems kind of just a figure that's plucked out of the air, for example, and that's why I feel oftentimes the Forest Lake comments about the rules that they have because they're a MS4, a municipal sewer stormwater systems compliant. And yes, I agree with the engineer that Columbus doesn't make that. However, it doesn't mean Columbus couldn't have ordinances, even though they're not MS4. And so I'm just wondering, how do we make sure that we're not having these more restrictive rules than what the state standards set, in statute or process, how that, to me, it's just unnecessary. Maybe we could just, so.
If I could comment just briefly on, so as a person who lives where they've got more houses on the lake than would normally have occurred because of cottages being built and turned into homes, I have neighbors who have been coming in and adding 10,000 square feet of fill on their property and flooding their neighbors. And if you make that an acre, the acre is, they're only a third of an acre lot to begin with. So I think that what I had asked us to look at, because I too don't want to be greater than we need to, because we granted a variance just recently to someone, is can we take a look at the individual circumstances of that fill and make a determination whether or not a variance would be appropriate or not? That's my solution to it.
Well, this isn't just a question of fill, this is a question of disturbance of property. And so I recently saw, although it hasn't been passed, in one of our contiguous watershed districts to the east of us in Washington County, that they were having a permit requirement for 250 square feet of disturbance. Now, to give you an idea, if you put a deck on your house, and it's 10 by 25, that's becomes an impervious surface above your ground there. And now you need a permit. And of course, with that permit, there were many, many other conditions that were required, for example. So I'm not just talking about fill as land disturbance. I'm talking about generating a permit with the land authority. And so I think that sometimes these rules are, and this is just my opinion for these words because I'm not an expert at what they mean, arbitrary and capricious, and they're just picked out of nowhere. And because, like I said, we went from 2,500 to 10,000, just like that. And these guys over there on the other side, they were thinking about going to 250 until the commotion in the public came about. And so I really emphasize that oftentimes the need for more standardized and of letting the cities make their adjustment through their land planning and are setting the standard. That's what the district says, set a standard, to set the minimum standard and let them develop what they need at their time. And I'll talk to you more about how to develop that idea through the 103B at the workshop.
Manager Waller, I just, in short response, of course, so the MS4 permit that's being referenced, it's a minimum control measure, and certainly if agencies want to be, I guess I'll use the term, more restrictive or have different thresholds, they can through their rules. And certainly, I mean, I know that we're not the same as other organizations. I know there are ones that have more restrictive, a 5,000 square foot trigger and things like that. I know to get to the 10,000, we've had an assessment. I don't want to quote a number and have it be wrong in front of you right now, but I know that there's an assessment that we've, what amount of sedimentation can occur from 10,000 square feet of just disturbance during a rainfall, like what that amount would be. I know that we have a number on impervious surface, what sort of rate you're going to get coming off of that. So I don't have that information in front of me, but we can provide that certainly for the November discussion as well.
I'm not going to hold you to provide that today, Patrick. Sure. That's not even for me. That's unnecessary. But I would say to you this is that we have stormwater ponds to catch the runoff here for these, and they're calculated at that size. So we have a safety device for the disturbance, and so do the cities too. And so as I say, if they need to have it, and land types change, especially in our district with the glacial drift and the Anoka sand plain and the muck soils here and there, so that you need to allow the cities to have that flexibility on their rule. Not that the district couldn't set a standard for it, but we'll have this discussion more often. It's been going on for me since March, so it's nothing new to you.
Any other further comments or questions? Take it there's no further action taken today, or is there?
Nope, you've received comments from the public and the board.
And then we'll close the public hearing and go back to our agenda. And I believe we are now at the open mic.
That's correct.
We're at the open mic. Is there anyone here who wanted to speak in the open mic? Not seeing any takers on that. Oh, there he is.
This is what I came here for. Good evening, or good afternoon, gentlemen, ladies. Christopher Stowe, 426 Pine Street. I just want to clarify for the record on those notes that it was Columbus that lowered the ditch on the north side of Pine Street with the blessing of the Rice Creek Watershed District to lower the pipe. I read through the notes and stuff, so, or the minutes that you approved today. So I just wanted to come down here and clarify that. And then I wanted to ask you guys, are we currently actively being fined or paying fines to the DNR? Monthly, quarterly, yearly?
Manager Bradley, there's no fines that the district's paying to the DNR.
Okay,
Yeah, I have no idea how they could do that or what it would be for.
okay. And then the 10/22/32, that's for the workshop, is that today?
The workshop was on Monday.
Okay,
We received information from Mr. Wagaman, Manager Wagaman, concerning a potential Coon Creek direction on a culvert. We've investigated that, and now in updates, we'll discuss that a little further unless we want to do that at this time.
It turned out to be inaccurate. That simple.
Yeah.
Manager Bradley?
Yeah.
Just to note, your workshop item was regarding alternative 4, and the board was contemplating the advancement in that direction.
Yeah.
And those, you reviewed the various alternatives that make up alternative 4, and one of which was maintenance, which awaits a conclusion on the DNR's position regarding rare and endangered species.
So at any rate, end result was that Mr. Wagaman, Manager Wagaman, has agreed to come into with his papers and cross-check them against the papers we have to make sure that we have a full record from the Coon Creek actions, which responded, calls Jodrell to be built.
okay, and then one other thing I wanted to clarify, because it was after the public mic, but John was talking. While the city did do a referendum, or what do they call it? Moratorium on building. It's only moratorium on building for single-family homes. It's not for commercial, industrial, or religious organizations or any of that stuff. So when they talked about wanting to build a mosque or wanting to build a retirement center, multifamily, whatever they want to do down there, the moratorium is only for single-family homes. So if they build in that floodplain, it's still going to negatively affect me. Thank you.
Wow, I got to look into that.
Okay, that takes us then to,
Yes, Manager Bradley, Board of Managers, your items requiring board action. Item number 1 is
Budget.
found on, I'm sorry. I was jumping right into the agenda item. Because
what's wrong with that?
Okay, permission to proceed.
Granted.
Thank you. On page 123 of your packet, or 124 is the actual item, you'll see the revised highlights. This is consideration of the resolution to adopt your 2025 budget and certification to the counties. I revised with bold italics the various items that the board discussed at its public hearing and otherwise. Those have been addressed for you to see and the public to be informed about accordingly. Otherwise, following that on page 127 is the resolution to adopt the budget. Notably, the whereas and therefores close out Fund 9501 and 9502. That's the Long Lake Sediment Basin, the Lock Lake Sediment Basin, and also moves those as those are covered under your project anticipation fund. That's Fund 99. And then there's a number of fund transfers that are within the documents that follow. That's on page 131. Show the fund transfers for your alignment with your fund balance policy. Those funds would then move to your project anticipation fund. And certainly it then does authorize the certification to the counties.
Does anyone have any questions of Nick?
I do, thank you. And I'm going to basically repeat what we dialogued in workshop. So my objection to what's in front of us today is what should be included in here is consider resolution to adopt a proposed 2025 budget. I did spend some time reading State Statute 275, and the requirement of the taxing agency is to provide a proposed levy and/or budget to the county auditor by September, allowing the county auditor to send out proposed property tax statements identifying all the taxing agencies on one sheet of paper between the time frame of November 10th and the end of November, so that we can at least be transparent with the public what we're dialoguing. Now, I'm not inferring we're being transparent, but I feel when I read the statute, I'm not an attorney, I will admit that. I watch a lot of Law and Order, but I'm not an attorney. It allows that for a reason, so that the taxing agencies can be transparent to the public. Now, whether or not the budget remains as we're dialoguing today at this dollar amount, that's fine. If it does, great. We know the ceiling can't go higher, it can certainly go lower. That's conversation that we can have in the next couple of months. But to me, to approve a final budget when that's really not the intention of the state statute, in my opinion, I'm not cool with that. Now, I'm happy to put a yes vote on this if this resolution were to state a proposed 2025 budget, so we can let the public receive the proposed property tax statement, so that we can hold that public hearing and then vote on a final budget by the December timeline provided for through that state statute. Again, this is just me. This is my opinion. My comfort level with it is not great. So either we amend the language, or if I vote no, that is why I would vote no on the resolution in front of us today.
Yeah.
I would do the same.
Manager Bradley, might I respond?
Please.
Just to make a note, we did hold a public hearing on the proposed budget, and it's before you today. And I believe the answer lies in a number of different state statutes, some of which are specific to watershed districts, our work to be compliant with all that exist. But you're right, in regards to the district cannot go higher than the current proposed amount, and then in December, there is the requirement of the public information meeting, truth and taxation, and the board might reduce the amount but not increase it, as you noted. And then typically what I recall from last year in December is that we just recertified because there was no proposed change, and just to make it clear that we had that meeting, et cetera. But I would ask Chair Bradley if we might hear from our attorney, just to make sure I'm noting that correctly.
And before I turn it over to Mr. Holtman, because certainly we want to hear what he said, I would note that, for example, the second whereas refers to concerning the proposed budget. I don't see where changing, if we were to add the word proposed in the heading, resolution adopted a proposed 2025 budget, add the word proposed in the first whereas in the third line, add proposed on the first therefore, it doesn't change anything.
No.
It just adds a layer of transparency. It doesn't change anything. It adds a layer of transparency with the public for us to hold a truth and taxation hearing after we've already made a motion and voted on it to approve a final budget. There's a disconnect for me in doing that. That's not truth and taxation. It's like asking for an apology after the fact. I'm not okay with that. That doesn't seem transparent to me.
It doesn't to me either.
Mr. President, are you making that a motion to add that language?
I was going to ask Mr. Holtman if he
I
had a
just-
problem with my proposal. As long as we're paying him, I will.
Mr. Chair, managers, Manager Robertson, you're referring to the state truth and taxation statute, which is a general statute that applies to taxing authorities broadly. It's a somewhat complicated statute, and parts of it apply to some taxing authorities and not to others. Also, in the Watershed Law, Chapter 103D, there's specific language about requirements for budget adoption and levy certification applicable only to watershed districts. And it's in that statute where there's a specification that before September 15th each year, watershed districts must hold their truth and taxation hearing and then must adopt a budget and certify, by September 15th, certify their final levy to the county auditors. And because that's more specific and more strict, then that applies and is a layer over top of the general statute. The obligation to adopt a budget before September 15th is because there's an obligation to certify the levy by September 15th. And in order to certify the levy, you first need to take a formal action establishing your budget. The fact of the matter is that you can change your budget at any time. So for the purpose of the September 15th levy, you do need to adopt a budget, and in that sense, it's a final 2024 budget as the basis for your levy. But after that point, you can, through discussion of priorities and intent for spending in next year, you can adjust the budget. You can raise it or lower it, and you can move funds from reserves or use grant funds or otherwise attend to adjusted revenues in a way that changes your spending and changes your budget.
So, Mr. Holtman, I note, as a quick read, be it finally resolved that a levy of $6,143,782 be certified to the counties of Anoka, Ramsey, Hennepin, and Washington, and levied upon all taxable property, et cetera, et cetera. So whether we put the word proposed budget or not in, we do have the certification provision very explicitly laid out. And we have the word proposed already in the second whereas. And so from my quick thinking, we are meeting our obligation. Your comment.
Not having it in front of me, the statute says, I believe, that the district shall adopt a budget and determine the amount to be certified to the counties by September 15th. So I won't quibble on the word proposed. I won't quibble. I don't think the state auditor is going to come and pursue the district because the word proposed is in the resolution.
Okay, thank you.
I personally would be more comfortable. It just seems wrong to me to have a public hearing after the fact.
I understand what your point is. I'm trying to accommodate it.
Yep.
Yes, yeah.
So I think that would be the way we go ahead. All we're doing is acknowledging the fact that the final doesn't get done until December.
Mr. President, I'm listening to Mr. Holtman. I have a question of you. Did I understand you to say that the levy is certified in September, and that's permanent levy? We can't lower that levy in December?
It is a final levy, meaning if you don't do anything else after September 15th, you've met the obligation that has to be met in order for the auditors to proceed and be obligated to extend that levy on your behalf. However, you can go to the auditors as a matter of practice before the end of December and reduce the levy, but not increase it.
Since you can reduce the levy, then the proposed budget and a proposed levy, actually.
Well,
Just a minute.
Rather not do that, because we're going to actually levy it. We're going to actually submit it. Go ahead.
I don't think it's all that one should be so definite at that decision, because the purpose of it, if you say that, if you're going to have that attitude, is that there's really no need for anything that's going to happen in the next 3 months and to have a final public hearing and the public come and decide. So I just, the definite solidness of your definition to me makes me uneasy. I would rather say this is a proposed budget, put that in the resolution, and I'd also because that gives you the idea that it really isn't a final tax levy, because it could be a change in the budget and a change in the levy. The levy is only, that's in here, is only to meet this particular budget at this time. Later on, when the final certification of the budget and levy occurs at the public hearing in December.
So, John, I assume that you're saying then that the language would change to read, be it finally resolved that a proposed levy of $6,140,000.
No, I wasn't saying anything about the proposed levy. I'm saying, when you say the levy isn't going to change, that gives the
Well-
impression that this whole period of 3 months in between in a public hearing is just a step-through formality that has no meaning. And that's not true here. The point here is that this is a proposed budget, and this levy can do it. What it is finalized here is that the levy can't go any higher than what it is today. That's what it is. But it can come down. And am I correct about that, Mr. Holtman? Did I understand you to say that it really, today's action puts a cap on the levy and it can't be raised, but budget actions and levy actions could reduce it. And the budget only just is the substance for the levy, you know. I mean, if the budget comes down, the levy comes down. And I think that clarity is to be understood.
Mr. Chair, Managers, that's correct, but I would advise against qualifying how the levy is described. I would not call it a proposed levy.
I didn't suggest a proposed levy. I was saying to you, it is a proposed levy, but it's a proposed budget that budget determines the levy. Now, I'm not, what I'm taking issue with is your description, Mr. President.
So, fine. So I would like to make a motion to amend the resolution to add the word resolution to adopt a proposed 2025 budget in the fourth line down. That in the first whereas on the third sentence, managers board adopt a proposed budget. That in the first, therefore, be it resolved that the Rice Creek Board of Managers adopts a proposed 2025 general fund, and that the rest of the resolution remain unchanged.
I think that works, doesn't
All
it?
right, is there a second then?
That works, doesn't it? I mean, I think that covers.
I'll take that as a second. Any further discussion? Yes, Chuck.
Yeah, Mr. Chair, Managers, just one further note to clarify. The further hearing that the board will have in December it's not a truth in taxation hearing, and strictly speaking, it's not a hearing. It's an agenda item. The Watershed District hearing occurs prior to September 15th. What we have is, again, the truth in taxation statute is complicated and doesn't entirely fit together. The legislature sort of did the best it could. And we went through several years ago to understand precisely how it applies to watershed districts. And in general, it doesn't. But there are just a couple of fragments of the statute in the way it's written that it does encompass watershed districts. And one of them is that there's this obligation in early December to simply give an opportunity to the public to appear before the board and speak to the budget and levy. And it's separate from the truth in taxation hearing. It's simply, you have to have it as an agenda item. And so we accommodate that and proceed that way. And on the basis of comments you get, again, you can take an action to reduce your levy.
My recollection is in the past years, in the past 9 years I've been on this board, we've never passed a motion at that point because we've never reduced it. We've just accepted the comments and moved forward. Yes.
I will be voting against that amendment because as I read this, Mr. Chair, it says in the second whereas that in August, we discussed a proposed 2025
Yes.
district budget. We are past that now. What we are doing here is basically for the purpose of the levy is telling the counties this is what we, at this point, believe our levy to be. If we have had discussion about the budget, and if we do indeed want to lower it, that would be the discussion we have in December, but right now, we are looking at a 2025 budget.
So the alternative discussion item I would propose then is that instead of adding the word proposed before budgets, we add a whereas the budget may not be increased, but may be decreased at the December whatever.
So, Mr. Chair, Mr. President,
work,
Mr. President, hold on. We have a motion on the floor. You have had a second to the motion. Are you proposing an amendment to the amended motion?
I'm proposing to withdraw that motion and replace it with a different motion.
Can I make a comment or ask a question?
Please.
There's nothing that precludes the watershed from being additionally transparent outside of the base minimums laid out in state statute, correct? Because this is my thing, is just the transparency just doesn't seem right. In addition to that, it doesn't allow me to fulfill my obligation to the county that appointed me here because, you know, counties, cities, townships, everyone else is doing their preliminary levies right now. So it just seems, and I understand statute is a little different as it relates to watershed, but this is my holdup. It's not the dollar amount. It's not that we can't reduce it. It's just, it does not seem transparent to me. And so I would suggest that you vote on the current amended motion that's on the table. That I will vote for. If you take the proposed or preliminary language out, I'm not going to. And it's not, again, because I'm trying to wage war on the watershed. It lacks transparency. And I do think that that needs to be a core tenet of any taxing agency that has the ability to increase or decrease families' budgets through property taxes. So that's my holdup. I'm not trying to pick a fight with anybody. I'm not trying to,
So I'm just asking you.
yes, please do.
If a more useful change would be to add a clause that explains the continued process.
As I stated, I would vote for the amendment that is on the floor currently. I would vote favorably for that, identifying what we're reviewing today as proposed / preliminary, whatever adjective we want to use. Otherwise, no, I don't think I would. And that's just me. I'm not asking anyone else to jump on board with that.
Mr. President?
You don't have to ask me. She said it as succinctly as I could, so I'm not going to repeat
So,
it.
Mr. President, I would call the question on the motion to have the vote, and then afterwards, if there's further discussion or amendments, they should be, at that time, proposed.
All in favor of the proposed change to Resolution 2024-06 to add the word proposed in the heading, the word proposed in the first whereas, and the word proposed in the first therefore, be it resolved.
So we're voting on the amendment.
We're voting on the amendment.
Okay.
All in favor, say aye.
Aye.
All opposed?
No.
No. So it passed, 3-2. And I voted no for the reasons.
I
believe It's
understand.
understandable.
I understand that.
Okay, so now, can I have a motion to approve? I will move to approve Resolution 2024-06 as amended. Therefore, it be resolved that the Rice Creek Watershed District Board of Managers adopts a proposed 2025 general fund and plan implementation budget totaling $9,410,614. Be it further resolved that the Rice Creek Watershed District Board of Managers approves a closeout transfer sufficient to completely close out Fund 95-01 and Fund 95-02, estimated to be net, I'll close it up, $516,883, subject to audited year-end closing adjustments, and further approves fund transfers in adherence to district fund balance policy. Be it finally resolved that a levy of $6,143,782 be certified to the counties of Anoka, Ramsey, Hennepin, and Washington County and levied upon all taxable property in the Rice Creek Watershed District for the year 2025 as authorized by the Metropolitan Surface Water Management Act, Minnesota Statute Section 103B.241, to pay the cost to prepare the district's watershed management plan and for projects identified in the plan as necessary to implement the purposes of Minnesota Statute Section 103B.201. And we have a roll call. Bradley, yes. Robertson.
Discussion first,
Yeah.
Mr. President.
Certainly. Discussion.
Yes, thank you, Mr. President. I'll be voting no today on this amendment, not on the amendment, but on the resolution. The resolution, in my opinion, as I said earlier last month, has $1.5 million in regulatory appointed. And these are our rules issues that were going on. And I think that that's just way out of line as to what we're spending on that issue at all, and that rule adjustment. So today's budget, of course, today's resolution, pardon me, resolution is setting a cap on the amount of money to be taxed, and I think that and it defines within this budget what the items are, and I don't agree with that $1.5 million in the regulatory area. So I will be voting no on it.
Mr. Chair, can I ask a clarifying question very quickly? You had identified some additional context language around this notion that it can be reduced, but it's
That was
capped.
if we didn't do this.
Got it, got
motion.
it, got it. So can you just again reiterate the motion before us is, I just want to make sure I'm clear because we've bounced back and forth quite a bit here.
So it is the resolution that's on page 137.
Including-
Excuse me, 127.
Including the proposed
Including one,
language.
two, three proposed.
Okay.
And I specifically read one of them into the record.
I appreciate the clarification, thank you.
Any further discussion?
I would just say one thing, Manager Waller, I do agree with you on I don't like that amount either, but I will be voting for it, but I think it's something we should definitely be looking at.
So we're going to have a workshop yet coming up where the rules will be discussed. And obviously, if we were to make some sort of wholesale change in the rules, you'd end up changing the budget, and that would be reflected in December. So I would ask you to consider voting for this, subject to whatever further change occurs going forward, so that we can proceed.
Well, to answer your question, Mr. President, I'm still going to vote no on this because I believe that way there'll be a record of an interest in having a very detailed discussion about those rules at that time.
Well, I'm
And
sure.
again, we have the opportunity to, in December, even though this doesn't neatly fit into maybe the other processes that the counties and the cities use, it still has an opportunity to reduce the budget and reduce the levy in December. And I want it known that I'm very strongly in favor of reducing those rules and changing that budget item. Thank you, though, for the consideration, sir. I appreciate the
Okay,
respect.
So I would like to call the vote. Bradley, yes. Robertson?
Yes.
Wagaman?
Yes?
Waller?
No.
Weinert?
Yes.
Motion passes 4-1. All right. Is there anything further on this item?
Just a moment, please, Manager Bradley.
I believe there wasn't a second on the resolution, the actual resolution. You read it into the record, but no one said second.
All right.
You know what, I think you said that mine counted as a second.
That's the other one.
Oh, that was on the amendment. Okay, I'm sorry.
Okay, so we get to go back and do this all over, guys. You don't have to do your speech.
Are you making the motion, Mr.
I will
President?
make the motion.
I will second your motion, Mr. President.
All right.
And we'll,
And we'll go forward with the on-the-record reading of the resolution. And I will call for the vote of Bradley, yes. Robertson?
Yes.
Wagaman?
Yes?
Waller?
no.
Wynant?
Yes.
Thank you very much for keeping us straight. I appreciate that, honestly. Do. Okay. That takes us to Jacon LLC final payment.
Correct. Manager Bradley. We have Tom Schmidt present to address that item. That's found on page 143 of your packet.
If you could all see,
Good morning.
come above the screen this time. Good morning, Mr. President, Board of Managers. Next for consideration is the final payment to JCON LLC for the Anoka, Washington JD3 branch 1, 2, and branches 1, 2, and 4 repair. This will be the final payment and close the contract out. It's important to note that while part of the project was intended to start in 2023 and a lot of the money was budgeted for 2023, but the work did not, the majority of the work has taken place in 2024. So that, that fund has gotten skewed because that money was in 23, but now the work was paid for out of 24 funds. The final payment is $27,731.22 and paid for out of ad valorem funds. And staff, myself, concur with the district engineer's recommendation, which is attached. And as part of that, district holds no additional retainage from JCON. This is the final and last payment to them for this project. And as part of that, we have a short presentation from Adam Neese, district engineer, on the results of the project and some of the challenges that were involved with the project. So, Adam?
Welcome, Adam.
Good morning, President Bradley, Board of Managers. Give me just a moment. I will share my screen. Excellent. Just a short presentation here recapping the construction project for the repair of Judicial Ditch 3, branches 1, 2, and 4. I will make it very clear. I have had several presentations with you all on the Clearwater Creek upcoming feasibility study and upcoming work. I want to make it clear that is not what we're talking about today. So I've shown on the screen here several phases of this repair project for this ditch. In the blue is the main trunk and branch 3 that was completed back in 2020. The red is the phase 3. So I'm skipping phase 2 momentarily. That is that Clearwater Creek stabilization. We've talked about the feasibility of different alternatives there, and we anticipate, if that moves forward, to have construction 2025 or into 2026. So what we're talking about right now today is phase 2, and that has been completed. And that is what's shown in yellow, those branches 1, 2, and 4 of the ditch. Talking some actual numbers here, when we talk about what the payment was, what the contract was. So shown on the screen, the original contract amount was $244,500 roughly. We did have some significant change orders as part of this project, totaling $61,398.50. And we have a final construction cost of $288,481.95. If you're pretty quick with subtraction, you'll note that those numbers don't quite add up. So I'll just note that there were several items within the original contract quantity that were adjusted down during the project that did not need to be completed. And those are not reflected in change order. Those are simply a reduction in the payment of quantities. The interesting thing shown in that pink text is the pre-bid engineer's estimate was $378,100 roughly. So even with the extensive change orders on this project and the total construction cost, we did come in pretty favorably under what we initially thought it was going to take to complete the work. So to date, we have made payments to JCON of $260,750.73. At each one of their partial payments, we have held back 5% retainage to keep them coming back to do the work that we're requesting them to do. So held to date retainage is $13,723.72. At this time, we are recommending release of that retainage as part of that final payment, including that retainage with the work that was completed but not paid for yet, totals our final payment, which Tom already said, of $27,731.22.
Any questions of Adam or Tom?
Mr. President,
I do.
oh, I'm sorry, you, go ahead.
Oh, he's got some more photos.
I do have just a few photos if you
Okay.
would like me to continue, just to summarize a few highlights of the project. Get that slide. I do want to make it clear that with any project, there will be continued maintenance requirements as we move forward into the future. Yes, we have completed the project. The ditch repair is done. The maintenance corridor is reestablished. However, there will be routine maintenance. We will need to do mowing and spraying, especially in these first few years. With any repair project, there tends to be more attention needed for stability of the ditch embankment. We will note that there will still be some amount of sediment depositing. There will be some maintenance required. We already have a beaver dam on one of the branches that we're working on taking that out again. So just to set our expectations, there will be maintenance required. Just a few photos here of the project work that was ongoing. Drawing your attention to the picture on the right first. There's kind of that green shed to help us see the same picture generally. So on the right is a partially complete project. We got the trees and woody vegetation cleared out and really gave a clear picture of a ditch or lack thereof. It's completely full of sediment and vegetation growing in it. So in this location, we took out approximately 3 feet depth of sediment, which is shown on the left, following the excavation of the ditch. So that ditch is now flowing pretty well. And this does not show the established grasses that we've got growing. It's, if we're going to go out there today, it's actually growing quite well out there.
Excuse me, 3 feet it took 3 feet to get to Ace?
Approximately between 2 and 3 feet through this stretch. And the other branches this was probably the worst. Most of the other branches were between 1 and 2 feet. But,
So, Mr. President, to add on to Manager Marcy's comment, the last time this drainage ditch was cleaned, I reckon, is 1959, more or less. And so we're talking about 50 years since we started in 18 on the main branches. And when you say there needs to be maintenance, I believe we must, the current schedule we have for maintenance and funds that we have dedicated to our 120 some miles of ditches is very inadequate. And so I look forward to seeing some expansion here, both in the staff and in the schedule of how that's done. And I just ask you a quick question, Adam.
Sure.
There was a gas pipeline, I think, on one of these branches. Did that ever get lowered, or are we still waiting, or what?
Yeah, there was a gas pipeline crossing.
Yeah.
And we did have the pipeline folks on site for several days while we were
Yeah.
excavating around those areas. They, as part of this project, the pipeline was not lowered.
Okay.
But they
It's-
were simply there to make sure that.
Yeah,
everything was
for
safe.
safety purposes, but I was just wondering where the schedule was and trying to lower these. We've got a lot of them to lower, I understand, but this one was there, so.
Mr. President, just to add to that, Flint Hill Resources, they're the owner of the pipeline. They have come in for a permit for that lowering the pipeline. I don't know what their schedule is for doing that, but we've been in coordination with them on the permit as well as through this repair.
Congratulations.
Very good news.
That's
Thank you.
very good news.
Just a few more slides here. We did have quite a few very large trees removed as part of this project. So shown here is the workers in action. You can see the size of some of those stumps that they're cutting down. Some of the trunks, you're actually seeing several large cottonwoods actually being dropped into the ditch. This particular picture was a very crowded residential area, and myself, as well as our Inspector Griffin and Ashley and Abel at the time, were out on site making sure that the trees being dropped were not endangering the homes. There was some fairly skilled chainsaw operators dropping these trees straight down into the ditch, and then they would chop them up and bring them out from there. So it was quite impressive to witness. The project did have a few challenges, one of which we're going to talk about here. There was a formal DNR wetland violation. Part of one of the branches does traverse a public water wetland. If you recall, the winter we had was excessively warm, and the contractor had strategized to complete the wetland work during the deepest part of the winter. So it was that 1 week or roughly 10 days where we actually had pretty low temperatures, and they thought they might have the best opportunity there to pack in the frost and actually drive their equipment out into the wetland and complete the repair that was required. That did prove unsuccessful, and they did begin to sink into the wetland. And so the kind of dark colored excavator arm that you see sticking out is a nearly completely sunk excavator up to almost the top of the cab. We did have to bring in assistance from Ramsey County, as well as you'll see those there's actually two big blue wrecker trucks that were brought out to help rescue the excavator that was sunk out there. So in order to get out there, they did have to build what we'd call a road through the wetland. So that encompassed construction mats and clay and gravel, and that fill was the formal violation of DNR. So fairly stressful few weeks there for us, working through that process with the DNR. They did give the formal approval of the restoration as they removed that road and restored the conditions of the public water there. Part of the creative solution to still complete the work that we needed them to do on that ditch repair was amphibious excavation. So that is an enclosed floating excavator track, and that was kind of neat to see. That was part of their creative solutions to get the work done. Just another winter shot here of that same area that we looked at earlier with the large tree trunks. This is also in process from that same day. And then just a couple quick highlights. So we do consider the capacity of the branches on JD3 fully restored, as well as the maintenance corridor. As you alluded to, that was part of the main problem, is not being able to get out there to access the ditch for maintenance. So now we have a nice 20 to 20 foot wide working corridor that we can actually bring in four-wheelers and other tracked backhoes and other equipment to do that maintenance work. We are considering the repairs to be completed under budget from what we initially estimated as part of that engineer's estimate. I will highlight that as part of the district specifications, we do have a strong specifications for these contractors. And we'll note that along with frequent meetings with the contractor were crucial to completing the project. So we had weekly construction meetings face-to-face with the foreman of JCON, as well as frequent emails and phone calls to give direction and frequent check-ins with our inspection staff who was on site daily as the main part of the construction work was ongoing. So all of that helped to keep the contractor accountable to do the work that they signed up to do and complete the project. Again, with the public water wetland, looking into future maintenance and cleanouts, we're going to have a bit of strategy there to get that work done as an ongoing maintenance measure, whether that's lightweight equipment or specifically timing out. I guess I may be the only one in the room saying, I hope we have a really, really cold winter and we can do that construction work, or the maintenance work, sorry, not the construction work, but just the future maintenance needs. And then again, communicating that long-term vision of the drainage projects to the landowners does remain critical. We had several landowner meetings, a public meeting before the project started. We had engagement with landowners as the project was ongoing. We had many meetings with landowners on site to talk about the ditch and talk about specific elements of their property, trees or sheds or gardens, and our message continues to be, please stay out of the working corridor for these ditches. And so that communication piece, we do a very good job, and we need to continue doing that for future projects. And just last picture here, a parting shot of a nice green corridor. This was taken back in July, so again, if we were to go out there today, it's going to be even greener and fuller than it is in this picture, but just to kind of give us a nice ending picture of something that's nice and green. This is that same corridor that's heavily residential. And as soon as we cleared out those trees, that sun hits that soil and that seed bed, and things do start to pop up pretty quick. So all in all, it's a successful project completed.
Mr. President, thank you. So Adam, I'm glad to hear you're having a lot of meetings with everybody that's involved, the citizens and the contractors. But please put in big bold print on your checklist from now on that there's lots of driving over the area where you were going to do the repair prior to bringing the machines in, maybe several weeks, regardless of how cold it is, to drive that frost down in the ground. So we'll try to manage being stuck in the mud to limit the management to limit that being stuck in the mud. I think that's. I know you can't control the contractor, but in your meetings, I did put that down as a big item. A lot of these guys that we hire, and they're good people, but they don't do drainage ditches every day, and they don't, and so they need the staff needs to have good communication with them as to what the risks are.
Mr. Chair,
Yes.
I would move to approve JCON LLC's final payment request as submitted and certified, and direct staff to issue payment of $27,731.22.
Second.
I'd second. There you go. All in favor, say aye.
Aye.
Any opposed? None. Okay, thank you. Good report. We have the check register?
Yes, Mr. Chair, I move approval of the check register dated September 11th, 2024, in the amount of $161,334.24 prepared by Redpath and Company.
I'll
Is there a
second.
second? Second. Any discussion? All in favor, say aye.
Aye.
Opposed? None. Okay, Chris, anything you want to tell us about your update?
Mr. President, I think I had 15 or 20 different items I'd like to talk about right now. I'll hold back on that, and address any questions you might have.
Very smart man. He reads the room.
Good man.
Anyone have questions of Chris?
All right, it takes us, I assume, to administrators' updates.
Thank you, Manager Bradley. Just a workshop follow-up item, the reference to Coon Creeks. I think there was some discussion earlier. We had a single page from that. I do have the minutes from the Coon Creek meeting that was referenced, and the item that was discussed at the workshop is indeed referencing a different project. It has nothing to do with ACD 102232 and the Joe Drill. That was a different item within the minutes. I'll dispense with these out to you good folks, and you can read at your leisure. We would like to provide a couple of public public drainage updates, if I could, quickly, with all the rain and such. So we had the concern at the sod, the sod farm, that private culvert. We have Tom here, thankfully, to help us through that. Tom, you want to give a little bit of an update, or I don't want to take away your thunder?
On the Butch Robinson culvert?
Yeah, yep, next steps there.
So as you may have heard, we've did some pumping around a potentially failing culvert on Robinson Sod Farms. The culvert was plugged with something, and the pumping was done to alleviate the immediate flooding upstream. We're looking to investigate further to verify its condition, whether it should be replaced or whether it isn't official obstruction. So that will take place. We're doing some survey work to get some preliminary indication. But until the water is low enough to physically see it, it's not going to be possible. Right now it's still mostly underwater on upstream and downstream. So
yes, so there, when we shoot the elevation on either side, we'll know if it's backed up, and being we can't see within the water or within the culvert, resolve from there. So we'll get that work going from there. Mr. Stowe is here. I wasn't at the last meeting, but concerns were raised at that. Houston is working on a memo. We'll have that on our October workshop. There's been some discussion, Tom, about Andal Street culvert. Maybe I'll turn that one over to you.
Sure.
Where
on
that's
the,
at.
sorry. Manager Wagaman had pointed out some concerns from a different landowner about possibility of Andal Street. So we investigated that same day or day before the previous board meeting and discovered that the culvert under Andal Street was experiencing a failing catch basin, and it's collapsing and it's full of sediment. And so I notified the Public Works of Lino Lakes, and they're addressing it and going to repair the catch basin and evacuate the sediment from the culvert.
Mr. Stowe?
Can I request that they lower it and increase its size since they've lowered the pipes north of me? Christopher Stowe, 426 Pine Street. So that pipe is negatively affecting me, as well as the next one downstream, which is there, and probably the one that crosses 4th Street. Because you guys have lowered those pipes, though, they not only need to be lowered downstream, they also need to be increased in size. Because that storm surge that we talked about before, where you have a storm base and you have water sitting out in a wetland area, that water evaporates or penetrates, we get a storm, let's say we get 6 inches of rain, that takes millions of gallons before it used to come to my property. Now, because it's at the bottom, it all comes right there, right now, and I'm underwater constantly. So every time you see the sod farms underwater, I'm underwater as well. Thank you.
Manager Bradley?
Yes.
Yeah, probably good to ask the district engineer, because I know we repaired this system previously, determined the ASIC, and then confirmed the culverts. if you would allow him to respond.
Sure. Yeah, so I have confirmed that the culvert is at the adopted profile elevation. That's why we didn't change anything when we completed the repairs back in 2013. We also, at that time, reviewed the size of the culvert. It was determined to be adequate at that time in the repair report. I'll also note that that culvert is larger than the upstream one at Pine Street. Another important thing to note is that the failure that is occurring is on a catch basin. That's the intake on the street from the curb line into the culvert. The city is not planning to make any change on the culvert itself. That would require a much more substantial effort. The city, of course, has the prerogative, as it is their infrastructure. They do have the prerogative to modify the size and elevation of their infrastructure if they would feel like it would suit their needs. But currently, the size and elevation is adequate for the drainage system.
It was adequate. Then you lowered the pipes upstream. And because you didn't lower the pipes downstream, that's why I'm further flooded out. Any engineer that's worth the salt knows water flows downhill, not uphill. So if you've got an inlet and outlet, you drop the inlet, you don't drop the outlet, I'm flooded out by definition. And you went 13 inches and you weren't supposed to do it at all. Thank you. I'd like to remind you of Rick Wilder and his situation, because my situation's very similar.
Manager Bradley, I'll just note that the request that I made to Houston Engineering and in the exploration to the original comment from the landowner doesn't include some assessment of, what would happen if that was changed. Further, I'd say consistent with what Engineer Otterness shared with you, our duty is to the ASEC and its functioning capacity. And so when those systems are built and remain in that condition, anything that would change that would be an improvement. And as likely the board knows in total, that requires a whole lot of protocol and work to get there.
And cost recovery.
And cost recovery from the landowners in that area. That's correct. Moving from there, Manager Bradley, just a couple more. Pine Street, we discussed that a little bit at the workshop. We're working on to get some bids and bring that back to you. We have to have the Wetland Conservation Act approval, which would be a permit that ties in your Wetland Conservation Act wetland bank credits, and obviously the board will have to make some assessment of the expenditure of those. Tom made a good point. Maybe we'll bring that back in October. Tom, in regards to the funds and the cost, et cetera, you mentioned Fund 80 and all the work we're doing. You'll recall, the beaver dams, the high water, the precipitation I mentioned at the workshop. We're spending through our budgeted amount, and those needs, including Pine Street and otherwise, remain high. So just advising you that we're nearing our budget amount, and we'll continue to monitor and update the board. We have the Sod Farm culvert, we have the Pine Street culvert, et cetera. And as I said again, we're at 150% of normal precipitation. That's a 95th percentile. That's a lot of water. In New Brighton, where the creek runs and we have a measuring station there, we're at 146 cubic feet a second. Normal is 40. So we're hugely over our numbers. And then in closing, I'll just make note that Emmett, one of our recent employee hires, quite a skilled gentleman on IT matters, which is what we hired him for, along with support for all of our programs, is putting forth some security efforts, making sure that we're all aware of phishing attempts and emails that promote us to do things that we ought not. So happy to pass that along. That's all I have.
Thank you. Manager update. Mr. Waller. Briefly, Mr. President, I attended the Washington County Consortium meeting. There were two topics, 3M settlement and how that affected it. And that's about those PFSA Forever Chemicals, and also there was a presentation. This presentation was by the PCA and the presentation by the Department of Natural Resources about the benefits of burning wetlands and forestry for how it goes along. I would just call your attention to go back and review a couple weeks ago, the front page of the, as they call it these days, the Minnesota Tribune, Star and Tribune, and the St. Paul Pioneer Press. They both have extensive articles about the forever chemicals. And what's unique about that article is that they review again that it's not just the dumps that 3M had, that we're talking about in Washington County. It's the extraction. These chemicals have been allowed to go into this public sewer system. They're in the sanitary sewer. They're also in the soils that are extracted out of at the sewer sanitary sewer facilities, and sludge, and that this sludge has then been for 40 years now has been spread across agricultural lands, not just here in Minnesota, but all throughout the nation. That the point that Maine now has made a law that says you can't spread it on ag lands anymore, because in Michigan, they found it is infected not only crops, but animals that are human food consumption. So, of course, it's often said that the solution to pollution is dilution. And in this case, then maybe the dilution is, because the reason we spread that on the fields is because of the 1972 Clean Water Act. You couldn't release it back in the rivers. And so, and they didn't want to put it in a landfill. So we have a kind of a problem there. With that, Mr. President, I yield back my time.
Marcy?
I have nothing.
Steve?
Just two quick things, and one is as far as what Mr. Stowe was talking about. I think that whole system is a disaster, and I know we've worked on it, but it needs to be fixed. Second thing, when I turned that document in, I said I did my very best to try to verify it, and I just want to thank Teresa for, she's a lot better investigator than I am. It didn't take her very long, and I spent a lot of time trying, so thank you. That's it.
My question, just verifying, you need me to attend the October CAC meeting, correct?
That would be correct.
Okay, October 2nd? Okay. I just want to make sure I have the,
I'm November, so.
okay, okay. I just wanted to confirm.
That's the
Thank
one.
you. Thank you.
Appreciate it. So my update is really quickly, I attended the CAC meeting when they approved a number of stormwater grants that will be coming back to us as a regular item. And considering the lateness of the hour, I will call for adjournment.
Second.
All in favor?
Aye.
Opposed? None. Thank you.